much. Dear organizers, Dear organizers, Professor Szilágyi, head of the Ferenc Madl Institute of Comparative Law, Professor Sándor Szalai, Deputy Commissioner for Fundamental Rights, Ombudsman for the Rights of National Minorities, and Professor Todd, who is also the editor of this book. Distinguished speakers, ladies and gentlemen, dear friends. People usually get together to accomplish something they cannot do on their own. That's the reason why the people build partnerships, why, for instance, we get married, why we form our societies, professional and others, and so on and so forth. And now, after listening Professor Szilágyi with all those accomplishments of the Central European Professor Network, what I know is just one small part, because I'm myself also part of the network and the digital platforms. This final closing conference was held, I think, a week ago, also here in Budapest. I can say that I'm really impressed with everything that's been done so far. At the beginning, I was impressed with the idea, with the concept, with the willingness and the commitment of all of those involved. And now, as we are dangerously approaching the end of this year, I am becoming more and more impressed with the outcomes. So, for excellent books, there are two Latin phrases that I remember from the time I was a student. I like to think it was not that far ago, but unfortunately it was, more than 30 years ago, is quod non est in scripta, non est in mundo. What's not in a paper does not exist. And the other one, verba volens scripta manent. Whatever we say, no matter how, brilliant it is, if it's not really, put in a permanent form of an article, of a book, expire from the memory of the people after a certain period of time. So that's why this book, together with the other books from the series, is something that is really, really quite impressive. And I would like to take the opportunity to thank Professor Szilágyi and to the partners from the Institute of Justice in Warsaw, for all the others, for the authors, of course, for the editors. I will try to say a few words about the book, but please, I would like to make a scrutiny reservation. I'd like to tell you that I'm not a constitutional lawyer, and I feel good in a company of so many constitutional lawyers. I myself I'm professor of criminal law. But this topic of constitutional interpretation is very close to my heart, because the very good friend of mine, a colleague of mine from the Department of Criminal Procedure, who was a constitutional judge at the time, he passed, unfortunately, 5 years ago, and he was really an excellent criminal lawyer or professor in criminal law, and I think that his contribution, his name was Davor, his contribution in bringing together these two, I wouldn't say the most important, but it's not far from the truth, maybe very, very important branches of law, constitutional law and criminal law. Criminal law is, as we all know, public law par excellence. That's actually the same with the constitutional law, where the concept of national sovereignty and the general rules is really in the focus, unlike maybe for some other branches of law. And he contributed a lot in establishing of some sort and a creation of some sort of the criminal constitutional law or constitutional criminal law. And this topic is very interesting because, as I was presented as an elected judge of the Strasbourg court, basically I'm just traveling this week to Strasbourg, where I take the office at the beginning of January. I'm still in some sort of a limbo. I'm not professor anymore. Well, technically I am until the end of this year, but we have no classes until the end of the year, and still not a judge. But I think that it gives me a very good, I would say, position to make some comments on this book on constitutional issues and a constitutional interpretation. So this is the third time that I'm participating at the event organized here in Hungary by either under the organization of the Model Institute or Hungarian government, and all 3 conferences in less than a month were somehow interrelated in terms of organizers and in terms of the topics as well. The first was the conference organized under the Hungarian presidency of the Committee of Ministers of the Council of Europe, titled European Court of Human Rights and its Case Law in the Application of Domestic Courts. It was held on 21st of December, not far from here in beautiful Festetics Palace. I addressed the conference with the topic application of the case law of the ECtHR in the Council of Europe member states. This conference was a high-level event, and many people from the constitutional courts, from the Curia, other prominent lawyers from Hungary, for instance, the current judge, Hungarian judge Pacolai, and the others attended the conference. The second conference was organized last week by the Ferenc Model under this very same project of Central European Professors Network. The topic was digital platforms and freedom of expression. Very, very interesting topic in these days of, well, this COVID situation we have to live with the fake news, disinformation campaigns, the role of the mainstream media, social networks, the role of the legislator, and so on and so forth. Unfortunately, due to the COVID restrictions, because I was in a contact with an infected person, I couldn't travel, so I had to stay in self-isolation. So I participated in a way I dislike, and it was online. But this time, I'm really honored to be here on this closing conference on this topic, on constitutional interpretation. And I would like to point at the fact that this conference, organized in Hungary and by Ferenc Model Institute, named after, well, distinguished lawyer, professor of law, former president of the Republic, has, in my opinion, symbolic dimension from the perspective of about 30 years since the transition started in Central and Eastern Europe. First and foremost, I see symbolics in one of the hypotheses from the research. And that is that the constitutional courts established in the Central and Eastern European legal systems after 1990 started to enforce human rights enshrined, I'm quoting, in their constitutions in a different context with different historical experiences and under different social and economic circumstances, legal and political conditions, and thus approached fundamental rights differently from their Western and Southern European counterparts. This presumption, in my opinion, it was, I think, well proved in this book, is not only well-established historical but also a legal fact, and that is something that is overlooked, sometimes even misunderstood, by some commentators, mostly from the Western countries. And that is where I see the importance of putting scholars from this region on the map through this project. All of these 4 topics that are covered by the project and the 4 topics that are announced for the next year. Because experts from the region that are at the same time top experts from the European perspective, certainly as insiders, have better perspective, experience, and acquaintance with the particularities concerning issues of constitutional interpretation in Central and Eastern Europe. As I had an exchange with Her Excellency, Minister of Justice of Hungary, Madam Judith Varga, said, if you are not invited to the party, you have to organize the party. And I think that it was really put it this way, there was really a good concept, an idea to put together the scholars from this region and to organize all of those dissemination events and to work on a book. Another symbolics, because we are in Hungary now, and Hungary obviously took a lead in this project, is that Hungary was the first country that joined in 1990 Council of Europe, the first country of among Central and Eastern European states. And just to put it in a historical context, to see actually what's really been changed in the course of these 30 years. It was 40 years since the adoption of the convention and 30 years since the first case of the European Court of Human Rights was delivered. It was Lawless versus Ireland, very interesting from the constitutional point of view. It was about emergency powers, right to invoke emergency powers. There was fight against terrorism at a time. And a court, and this first decision, Philip Jessup made a comment on the occasion of the first judgment that was delivered by the court at a time. As beautiful as a Sputnik is the launching of the European Court on Human Rights on the occasion of the Lawless versus Ireland. And I think that some of the parts of this very important decision are still very relevant and still very important today when we are discussing about the emergency powers in the countries as a response to the COVID situation and so on and so forth. 1990 was again the year when the Venice Commission, which is very relevant for the constitutional law, was established. It was just a year after the beginning of the work of the Committee on the Prevention of Torture, and, last but not least, the year after the first woman was elected as the Secretary General of the Council of Europe. That was Catherine Lalumiere. Today, I can say it proudly, we have many women on a leading position in the Council of Europe, and many of them are from this region, Central and Eastern Europe. We have Madam Pejčinović-Burić, who is the Secretary General. She's from Croatia. Dunja Mijatović is the Human Rights Commissioner in Strasbourg. A colleague of mine, Ksenia Turković, is the Vice President of the Court, and so on and so forth. So I think that the world we live today, that is very complicated and multi-layered, multifaceted, changed in the meantime since 1990. But this project, together with all the other projects that are run by the Ferenc Madli Institute, showed somehow that it is very important to take note of these changed circumstances and to these complexities and dynamics of the world, with, of course, legal implications, especially in the field of constitutional law, but also other branches of law to this world. Now, let me say a few words about the book that really looks impressive. It's very heavy, not only, I mean, in a physical sense, but it's heavy in terms of the contributions, valuable contributions of the authors. Editor is Professor Zoltan Tot, who is Professor of Law at the Department of Legal History, Jurisprudence and Church Law of the Faculty of the Karoli Gaspar University in Budapest. And the contributors are all professors. Benjamin Flander, who is Associate Professor of Law and Head of Legal Department at the Faculty of Criminal Justice and Security of the University of Maribor. Adel Kebelish, who is a Senior Research Fellow at the National University of Public Service in Budapest. Associate Professor Piotr Mostovic, Faculty of Law and Administration of the Jagiellonian University in Krakow. Professor of Constitutional Law and the Vice Dean of the Faculty of Law of the University of Novi Sad, Slobodan Orlović. David Seknalek, Vice Dean of the Faculty of Law of the Masaryk University. And Professor Katarina Šmigova, who is the Dean of the Faculty of Law of the Pan-European University and Associate Professor at the Institute of International Law and European Law of this faculty. So the book and the methodology used in the book, covering these 6 countries in alphabetical order: Czech Republic, Hungary, Poland, Serbia, Slovakia, and Slovenia. Each of these researchers had the following task, and not an easy task, I must say, to define the most important 30 cases in which, in the last 10 years, the Constitutional Court of a given country decided on the merits and which contained a substantive reference to either European Court of Justice or European Court of Human Rights decisions. So if my understanding was correct, these 30 cases or 30 decisions were majority and only majority decisions, not the minority decision, not dissent opinions or concurring opinions of the judges of the Constitutional Court of a given country. If I just may, as a criminal lawyer, not a constitutional lawyer, maybe for the future this could be maybe a room for, well, for the next step in this analysis to take into account also the minority decisions, dissents, and concurring opinions as well. Because we know they're not legally binding, of course, but you know, sometimes I know as a scholar, and I'm sure that it is a case with you as well, sometimes I more refer to some of the dissent opinions of the judges from the Strasbourg than on the majority decisions. I can give you a few examples. For instance, this is from my field, and I know that this is very relevant for the Hungary because there have been some cases before the court on the life imprisonment and the right to parole or conditional release and so on and so forth. What is very often quoted in a literature is this phrase, right to hope. That was basically the concept that was established on the basis of the dissenting opinion of some of the judges in the Winter case, Hutchison case, and some other case. So the person has to have a right to hope so that he or she will not be imprisoned for the rest of their life, but she will get an opportunity to challenge the decision of the life imprisonment, and that this decision should be reconsidered at a given point of time by either a court or the president or the republic and so on and so forth. Or maybe another very good example is the former Portuguese judge, Albuquerque de Pinto, actually, who just published a book recently about his dissenting opinions. It's really a quite impressive piece with all of his dissent opinions throughout the years. And I can give an example from my country, from Croatia. The recent case that concerns Article 4 of the Convention, it's the prohibition of slavery. The Strasbourg court found Croatia in violation of Article 4, and it was the Grand Chamber decision. And it was a case of the exploitation of the prostitution. So the basic argument of the court was that Croatia violated Article 4 because the victim of a human trafficking and a victim of exploitation of the prostitution was not given, I would say, the proper treatment in the course of criminal proceedings. So she was not trusted, her statement was not taken into a serious account, all lines of investigations were not effectively addressed by the authorities, and so on and so forth. And this is now the problem for the country because there was a Grand Chamber decision. But as I say, as I said already, I think that every challenge is at the same time the opportunity actually to change the system, to improve the practice, and so on. And the reason for this Grand Chamber decision, in a way, was, well, of course, the fact that the country requested for re-examination of the case by the Grand Chamber. But I think that a very good impetus for improvement of the judgment at the end by the Grand Chamber was the dissent opinion of Judge Koskelo, Finnish judge, who, dissented to some of the findings and some of the legal reasonings of the majority in the Chamber case. So that's why I think that maybe dissent opinions, and by the way, when we are talking about the authentic will, or I don't know how to put it rightly, of a judge in a concrete case, because as we know, those who draft judgments and the decisions in most of the constitutional courts, even in Strasbourg, are lawyers, not the judges themselves. But those actually who dissent, they have to draft, I know because I asked the colleagues at the registry, they have to draft actually their own dissents or their concurring opinions, and this is really, in a way, I would say, an authentic will of a given judge, and not really the draft that was prepared by someone else within the system. So what is the result? What were the results of the research? In very short. when it comes to the external, because I'm sure that Professor Todt will talk more in detail about the results of the research, but let me to give you a few very short remarks on this. External systemic arguments, so the ECtHR and ECJ, so by the examined constitutional courts, external systemic arguments were applied, according to the editor, to a significant extent, but slightly less frequently than domestic systemic arguments or grammatical interpretation. So, to put it in a simplistic way, the more important the case is, or the high-profile case, the more common is that the constitutional courts invoke or refer to either ECtHR or ECJ judgments and decisions. In some cases, these references are very common, while in some cases of some countries, not so common. I can tell you, well, there is not a constitutional lawyer from Croatia in this project group, but I can tell you from my experience with the Constitutional Court in Croatia, when there are some very important political sensitive cases, the Constitutional Court tries to engage more in the reasoning using the arguments of these supranational courts, Strasbourg Court and Luxembourg Court. There was a very interesting case back then on the it was a constitutional complaint. Well, we have this very specific situation in Croatia because the constitution was amended. It was about 10 years ago in order to enable the prosecution for economic crimes committed in early 90s during the privatization process and the cases of so-called war profiteering. Although cases that were time-barred because the periods of limitations expired in the meantime, and then the constitution was changed in order to enable the prosecution. But then the question arose how to interpret. There was a question of, well, basically the constitutional interpretation, how to interpret this provision of the Constitution, because itself it was a part of the principle of legality, and we know that very important feature of the principle of legality is prohibition of retroactive application of a law. So what does it mean? Would it be applied, ex nunc from the moment that a constitutional amendment entered into force, and all the cases that were barred until that time that was not anymore possible to continue with the proceedings, or does it refer, or does it relate only to those cases that were not time-barred at the time when the Constitution entered into force? So, very complex legal situation, but in a short, that was, well, the constitutional complaint, not in abstracto constitutional review, because the Constitutional Court, of course, cannot review the provisions of the Constitution itself, but only of legislation and so on. So, and I remember very well, because I studied very thoroughly this judgment, that a court referred to the case law of and to the jurisprudence of the Strasbourg Court from all of those cases, from Strelec, Kessler, and Krenz versus Germany. Then the cases against Russia, Litva, and other cases concerning Article 7 and the principle of legality. Then when it comes to the comparative law, the occurrence of comparative law arguments is not very common, according to the result in Central and Eastern Europe, but still remarkable. And in most of the cases, the role of the comparative law arguments is illustrative. So when a court has to find something to strengthen, to support the position, they usually refer to some judgments of the foreign constitutional courts, and those constitutional courts that are quoted more frequently than the others are German constitutional courts, Bundesverfassungsgerichtshof, and well, the Austrian and the other courts in Western Europe. For instance, in Czech Republic, out of 30 decisions examined there was at least some reference to the comparative law. 21 contain such argument in Slovakia, 18 in Hungary, and so on and so forth. Another interesting issue is the work of the prominent scholars. It could be, as we know, the source of international law as well. And then the question was, to what extent is this used by the constitutional justices? In some countries, references to these scholarly works barely appear. Hungary is, for instance, example for the country, and Serbia as well, that was employed only once, while in some countries, as Slovenia, for instance, it is very common that work of the prominent scholars, the lawyers, has been quoted. Slovakia as well, and in some other countries. When it comes to the grammatical interpretation, the hypothesis was that this is the major method used by the constitutional courts. But according to the editor, this was proved only partly by the results, while dogmatic interpretation actually proved to be frequently used method. Then the other methods and the attempt to explore the everyday meaning of the words was either absent from the most of the decisions or was present only in a few cases, for instance, or very occasionally in the jurisprudence of Polish, Slovenian, Serbian, and very seldom Hungarian free cases of the constitutional court. So in short, this is about the results of the study that is contained in this, as I said, very, very impressive book. It's really a special moment for all of us. I mean, we are scholars, and we know what kind of the feeling of and the excitement it is at the time of, so to say, delivery of a book. It's really like a baby. So it's a small baby now, although it's very heavy, as I said. Well, this is the baby. I hope will have, well, the long and prosperous life. It will be disseminated widely. I think this is really a challenge. This is really important because now here in the region we all know about the Central Professors Network, we know about the Ferenc model, but it is very important to send a message to those who might not be quite acquainted with all those accomplishments and to send them a book. This could be, I would say, the best reminder. I really do hope that apart from having hopefully this long and prosperous life, this book will affect the lives of many, and also the constitutional interpretation, not only here in our regions, but also in Western Europe. And I'm sure, because I will talk to my colleagues in Strasbourg, that we also take this book in our library. So thank you very much for your attention. And I don't know, are we good with a schedule? Because unfortunately, one of the colleagues had to cancel. So if you have any questions after the Professor Zoltan taught intervention, I would be glad to try to answer to your questions or to have a debate. Thank you.